of a car that somebody lost. It's a Renault. And the key is with Ines, who is there on the left. So if you have a Renault and you want to go home, tonight you can get the keys, otherwise it will be tomorrow and we will use it. So I now give the floor for the last session of today to our chair, who is Professor Achilles Skordas, who is Greek but working for part in the UK, another part in Germany, so to say, so a real European, and a specialist in particular of international law, and he looks very often through the lens of international law to the issues of migration and asylum. Achilles, you have the floor.
Oh, yeah, okay. I thank you, Philippe, for your kind words. I will restrict myself today to my obligations and duties as a chair, and I will not express any positions. I thank you all for your patience being here in the last session of the day. And I would like, before introducing the members of my panel, of our panel, I would like to say that I learned very much from our colleagues today. In particular, I realized in depth, it's not simply to know it, but to see it and to feel it, the levels of complexity and ambiguity that the new system has. And my impression is that when we try to resolve issues as complex as migration, we create new legal instruments that shift the contestation on a different level. There is nothing definite in deciding a number of regulations or directives. The disagreements continue, and the struggle for semantic domination goes on different levels of the normative and political system. But let me introduce you the topics and the members of the panel. We discussed today, mainly in the fourth session, three big topics: reception conditions, second, qualification regulation, and third, protection and identification of vulnerable persons. So the session is about what are the rules for refugees or for asylum seekers when they are in the territory of the Union, not anymore at the borders, not anymore in the path to Europe, but what happens when they are in Europe. And our panel appears to be bigger than the others, but this is only an impression because the time is exactly the same. So let me begin by introducing you our speakers, Professor Ségolène Barbou-Desplaces from Université Paris 1, Nina Roques, or Roques, Deputy Chief of Cabinet of the State Secretary for Migration and Asylum in Belgium, Professor Boldizsár Nagy from Hungary, who has until recently taught at the Central European University in Austria. And, you know, I'm thinking of Boldizsár, whom I've known for more than 20 years now, that he really personifies the old Austro-Hungarian connections on many levels. So it's a really cosmopolitan person. I speak about him because I've known him very well. Dr. Catherine Waring and Dr. Valeria Ilareva. I apologize for my slow reading, but I'm not eagle-eyed, rather the opposite. And finally, last but not least, our British colleague, Professor Steve Pearce from the Royal Holloway University of London. We will start with Professor Ségolène Barbu-Deplace, who will discuss the question, better or no reception conditions with the new directive, question mark. Thank you, Ségolène.
Thank you. Just wait a couple of minutes or seconds for the PowerPoint presentation. Hopefully. Should come. Well, the topic and the question I will try and answer today is the question asked by Philip. So when reading this new reception condition directive, can we conclude that there are better or no reception conditions? So to try and answer this question, or to give some elements, because as you will see, I will open a lot of questions and probably not answer all the questions, but I would like to make 4 points. The 3 first points will be observations. I will first make the observation that the categorical approach to asylum seekers, that is not new, is confirmed, and maybe its effects are increased by the new reception conditions directive. The second observation is when we read the text, it's quite striking that it's modeled or embedded in the rest of the pact, and in many aspects, access to reception conditions are in the shadow of other texts of the pact, and in particular, the Dublin regulation and the APR. The third observation, which is really striking, is that the directive increases welfare, but clearly to the detriment of the autonomy of asylum seekers, and in particular to the detriment of their free movement. And finally, I will open some questions, and really, as you will see, I will not answer the questions, and we'll probably have time to discuss that during discussion. So the first aspect is this categorical approach to asylum seekers. We could simply say that there are more rights granted by the text, but not for all. I've here mentioned a number, given a list, which is a non-exhaustive list of rights that are strengthened and guarantees that are added to access to the reception conditions by asylum seekers. So I'm not going to read everything. So they range from better definition and increased definition of reception conditions to better consideration of people with reception needs, also better access to the labor market, safeguards, I will come back to that, the safeguards against detention. And I think there are important elements like the fact that detention is not allowed solely on the basis of nationality, and detention cannot be punitive. Or other examples that I mentioned, such as, for instance, the fact that member states are called to adopt contingency plan, sorry, it's difficult for my French mouth, contingency plan in order to anticipate situation of disproportionate number of people arriving, and in order, of course, to improve receptions. So it's clear that the text increases the number of obligations for member states, including procedural obligations, which can be very important in terms of protection. And also it's striking that there are obligations that are not new, but they are more comprehensive, including a stricter deadline or deadline that did not exist. So there is something new, and in a way, there is really a positive aspect in this new text. But at the same time, the rights are very unevenly distributed among asylum seekers. To start with the positive aspect, there are categories of asylum seekers that are targeted specifically in order to improve their access to reception conditions and the list of conditions that they will enjoy. And just to take one example, it's of course the case of all these people mentioned as persons with specific reception needs. And interestingly, in the text, the list of these people has increased, including now LGBTI applicants, but also persons suffering post-traumatic stress disorders. So there are a number of provisions that include new reception conditions for them. I've mentioned just a couple of them, but for instance, the last one for me is quite important. The fact that where the detention of applicants with special reception needs would put their physical and mental health at risk, in that case, those applicants shall not be detained. And it's a really much better protection than what we had in previous Article 11 of the 2013 Reception Condition Directive. But on the other hand, of course, the categorical approach serves or can be used to exclude other people from reception conditions. And to take, once again, some example, but it's not exhaustive, but I will come back to that as well later. Of course, people who present the risk of absconding, of course, they can suffer restriction to freedom of movement, greater possible use of detention. Another category, of course, is asylum seekers who have sufficient means, and it's quite striking in the text that they are required now to contribute to the cost of language courses, material reception conditions, health receives, etc. And there are two other categories that I want to mention, but this leads me to my second part, which is really the fact that, in my view, the Reception Condition Directive is really in the shadow of other texts of the Pact. And to illustrate that, I would like to take only two examples. The first one is Article 21 of the Reception Directive. It is a text that is a new article which imposes the removal of reception conditions by member states from the moment that applicants have been notified the decision to transfer them to the member states responsible in accordance with the regulation, with the RAM or MMR. And this is really striking because this will entail a very restrictive evolution in comparison with what exists now, because it simply means that for the persons under Dublin transfer, access to most reception conditions will be denied since notification, which is a major change. And to have a precise idea of how long this will be, the deprivation of our reception condition will be, then we have, of course, to refer to all the details of the RAM. And as you can see, it can be very long, 6 months plus in certain circumstances, 1 year plus sometimes 3 years. So there is really here, when reading this provision, it is striking how far the logic of Dublin seems to spill over into the logic of the Reception Condition Directive, which is supposed, and it is clear when reading recital number 10, that the text is supposed to be, and the aim of the text is supposed to be that of providing adequate standard of living and comparable living conditions in all member states, not to deprive people from access to reception conditions. Another example, I will be very quick on that because it has been already discussed by Catherine Wooland. It's the example of Article 10, fourth paragraph of the text on grounds for detention. So there are a couple of amendments in the text on grounds for detention, and I just want to focus on one, which is the C. And in comparing the two versions of the two texts, in the current text, applicants may be detained only in order to decide in the context of a procedure on the applicant's right to enter the territory. And in the new version, it's much more precise, and it's really pointing at Article 43 of Regulation 1348, which is Article 43 of APR, which is the text in which the legislator has agreed to accelerate, not to accelerate, but to organize the border procedure, and where it is mentioned that there is the so-called fiction of non-entry. So once again, it seems that this provision in the reception conditions is aimed not so much at organizing reception conditions, but rather at organizing and ensuring the efficiency of the asylum border procedures. Third, the third observation, which is really striking one reading the text, is that there is indeed increased welfare, but it's a sort of deal to the detriment of asylum seekers' autonomy. And this is very easy to observe when you pay attention to the different provisions that limit free movement to asylum seekers. So Article 8 that I mentioned is not new. It already existed, the possibility for the member state to allocate asylum seekers to specific geographical areas. So this is not new. But what is striking is the second element, that member states are not required to take administrative decision to assign an area, and member states are not obliged to enable applicant to lodge an appeal against the allocation. And there are, of course, consequences for non-compliance. These consequences are the loss of entitlement of material reception conditions. But what is new is Article 9, which is named restriction of free movement. And before that, in the current directive, it is free movement. So it's significant that now we focus on restrictions. And with now this possibility given to the member state to assign to asylum seekers a specific place of residence. And this can include reporting obligation to national authorities. And only upon request of applicants, member states may, and not shall, grant permission to reside outside this specific place. And once again, there are very strict consequences for non-compliance that are organized and that suppose that applicants will lose material conditions. So once again, we can see, and I conclude just with this idea that you can find in the text by Linnekus Lingenberg, that you can find in the Odysseus blog, really concluding that there is dignity that is taken into account, but probably without autonomy. And to put it, it's the same idea, but to put it differently, it's maybe the belief that the EU has to promote this so-called objective conception of dignity, meaning that, of course, it is important to ensure that people do not find themselves in a situation of extreme deprivation, but dignity would not include self-determination, and in any case would not include the choice of where you want to live. And to end this presentation, just a couple of open questions. The first one is about semantic, and I'm really wondering, I have no answer to that, but it's striking that there is a change of semantics in the text. And I'm really asking myself and you whether you think these semantic changes entail a conceptual evolution and if they entail legal consequences. I just want to mention two of them. Dignity was central in the text, which we still have, so the text adopted in 2013, except one case, it has completely disappeared. And now we have this notion of ensuring people a standard of living in accordance with union law, including the Charter and international obligations. So does it change something? I don't know. Of course, in the Charter, we have dignity. So maybe it changes nothing. Or maybe dignity is not only in the Charter, but dignity is also a value mentioned by Article 2 of TEU, and the Court of Justice increasingly refers to the value of Article 2. So I don't know, but it's an open question. A second semantic changes is the shift from the notion of vulnerable persons that was constantly used, and now in the text we have this notion of persons with special reception needs. Once again, I don't know whether there is a change, whether you can see that something happening, or if it is the result of political discussions. If you have any information, I would be really glad to learn. And just to finish, my last question is whether this new reception condition directive is fully in line with European Court case law and human rights instruments, So just two examples, but I could take many of them. But the first one, of course, is this new Article 21, which imposes the removal of reception condition from the moment applicants are notified of their Dublin transfer. Is it fully in line with the GISTI and CIMAD case? Of course, there is a difference now, because in CIMAD and GISTI, the court could deny the French government the right to refuse applicants under Dublin transfer access to protection, because there was nothing in the text. Now there will be something, because the new text provides for the possibility to refuse detention condition, but still the courts also referred to dignity. And in this part, you can see that for the court, it's quite important that the requirements of Article 1 of the Charter, under which human dignity must be respected and protected, means that asylum seekers may not be deprived. It means that my time is over. Okay. So anyway, the last one has been already very much discussed, in particular by Galina, and it's about this gray zone. How do you know that it is a detention or restriction of free movement when someone is assigned to a specific place and has to report to national authorities? So there is really a gray zone. And what I mentioned here, quoting the European Court of Human Rights and the Court of Justice in Luxembourg, is that really there is a gray zone. And that's really my conclusion, to try and answer Philippe, who asked, are there better or no reception conditions? Probably both, depending of who you're speaking about, but only if, because conditionality is really a guiding line of the text. And maybe also the answer is not an easy one, Philippe, because the answer is not only in the text. It's in many other texts that have already been quoted since the morning. And this will be the transition to the next person. Of course, there are main remaining implementation gaps that are not solved by the new text. Thank you very much.
Thank you, Ségolène, for the presentation and the way in which you analyzed the texts. I like the way that you interpret it in a temporal perspective with regard to the currently applicable law, but also systematic in the context of the other acts that were adopted this year. Also, I think in the issue of vulnerability, vulnerable versus special reception needs, as I read it, and I have no information at all, but I try to see the objective meaning of the words, vulnerable is the totality of a person. And it is a term which has been highly hijacked by the political discourse. So to put it down in the language of special reception needs, it tailors it to the logic, rationale, and function of the specific legal act that you have analyzed. Thank you very much. Yeah, and now it is Nina Roques who will comment on this topic, I assume. Yeah.
Thank you. Thank you. Well, comment is maybe a big word, because I will just shed some light on the Belgian situation. Philippe de Braque sent me some questions to respond to, but it's really useful that Professor Barbu already gave us the overview of the new reception condition directive. I could talk for hours, and you have already been talking for hours about the importance of the pact, or the possible impact of the pact, but also for the political level on the Belgian and European policy level. Of course, it has its flaws, and I'm sure you discussed lots of them today. And it has there are a lot of questions raised also by Professor Barbu. Unfortunately, I will not be able to tell you all about the implementation questions there are, because they are, of course, still existing. But it's for us, or for our state secretary, at least for Belgium, this is the only thing we have at the moment to respect the right to claim asylum on European territory. For the Belgians around here, I think you saw today's press. There's a lot going on the Commissioner von der Leyen's letter on alternatives, Australian model. The Belgian politics talk about this a lot, but the pact at least guarantees that an applicant can apply for asylum on European territory. But of course, a lot will depend on the way we implement and the way other member states implement these new regulations and directive into practice and into law. But I will only discuss the reception conditions directive. However, it is linked, as Professor Barbot already said, to the other text. It is a package. It was discussed as a package, and we should read it that way. We cannot just focus on one of these texts. But to start, maybe shed some light on the current situation in Belgium. There are, I'm sure, some Belgians in the room that are quite up to date, but maybe for those who aren't, the Belgian reception system today is insufficient. We know this. We currently are still working with a waiting list for single men, so they have to subscribe to wait for a reception place after applying for asylum, which is problematic and not in line with the reception directive, as we know. So I can hear you thinking, why don't you just create more reception places? And it was also one of the questions I got, which seems a very logical and obvious question. But I think it's interesting to show you how we got to this point, because of course Belgium is known as a state with respect for human rights and normally obliging international and European law. First of all, the previous government closed a lot of reception centers and individual reception places, which at the time was possible because the influx of applicants in Belgium was low. Unfortunately, when you burn a bridge, so to say, it's difficult to rebuild it afterwards. Because we saw after the pandemic that the arrivals in Belgium, the numbers rose again. I think today we are already, for 2024, we are already at over 28,000 arrivals or asylum claims at the moment. So this is a high number. This puts a lot of pressure on the reception network. There was also a question about the profile of the arrivals in Belgium. So as you know, a lot of them, a lot of people are secondary, I don't know how to call the people that do secondary movements, but so secondary movers, applicants who are already known in different member states. We can see that over 50% has a Dublin hit, so is known in another member state. So it doesn't mean that the other member state is responsible, of course, but another significant group are those who apply for international protection in Belgium, but who have a marked status, meaning that they already have been granted international protection in another member state. The biggest group, and this was also in the Belgian press today and yesterday, are Palestinian refugees who passed through Greece. They got protection in Greece and travel on. I will not discuss this in detail, but of course, we know the situation of those refugees is quite difficult to assess. And more general, we also see a large group of people with a low protection rate coming from countries where the protection rate is under 15%, so to say. So we have the reception network that shrank and that was more difficult to re-expand afterwards. Then we have the difficulty of the outflow of recognized refugees. The protection rate in Belgium is always around 50% somewhere. It goes up and down, of course. But we have a lot of recognized refugees or persons with international protection, including those with subsidiary protection, of course. But we can tell that they have a lot of difficulty leaving the reception network. It's not as bad, so to say, as in the Netherlands, where the reception network is full of people who already have been granted a status, but it is an issue. The Belgian politics are really complex, but housing is not a federal competence, but it is our problem because we want people to leave the network in order to make place for new arrivals, people who arrive. So that is why Fedasil has been focusing on measures that allow applicants and refugees to be more autonomous. I think the days are past that we looked at applicants for international protection as just passive persons who are in a waiting room waiting for the decision. We've been working on guidance to work, but also we provide social legal assistance outside of the reception network because we know that this is a big obstacle. When you leave the reception network, suddenly you don't have anyone helping you out anymore, or in Belgium at least it's that way. So we've been working on these measures as well, because of course, if an applicant for international protection has the option to live somewhere on his own, that's what everyone prefers. No one prefers to live in a collective reception center. That's clear. And then I think the last point is that the processing of asylum claims in Belgium takes way too long. We have invested significantly with this government in our services in order to shorten the procedures, because of course, if the procedure takes longer, a person needs a reception place, and you need it for a longer time. And this investment, we did a calculation. I cannot explain it. I'm really bad at math. I'm a legal professional, so we're not known for our maths. So we did the maths, and it saved us the need of 17,000 extra reception places just by investing in our asylum services. So you see, if we talk about being well prepared as a state, it's not only the reception network, but it is, and I think for Belgium, that's a really, really important point, that is also to have enough staff to assess the asylum claims. But of course, we expanded the network significantly. I think the government has created over 10,000 places since the beginning of the crisis, so since a few years, which is a lot. We've had temporary places, we used youth shelters, but also structural places. We worked together with new partners, old partners, with the Brussels government. There was no taboo on having housing for people, but the reality is that there are so many obstacles, practical, safety, logistical. It's not easy. You cannot just put someone somewhere and put a bed and say you've done what you could. And then next to this, there is the increase of lawsuits of local authorities, who are also public authority, but who do not want a reception center on their territory. And unfortunately, where I think 5 to 10 years ago, this used to be a lot of political discussions, but today it is a legal discussion in court on details and urbanistic questions, but it's clear that local authorities sometimes go all the way to prevent opening a reception center. But these 10,000 places, it's not sufficient. And we can tell, and we talked about this, of course, also with the European Commission, we need a reform of the European system to lower the arrivals in Belgium. And with the package of all the different texts, we can expect arrivals to be lower in the future for Belgium. But the question I got wasn't the package, but will the new reception directive help to resolve the reception crisis? This is a nuanced question. I think Professor Barbu already gave us some interesting points or interesting elements. But it is clear that the new directive towards some asylum seekers gives us a bit more marge de manœuvre. However, and that is what Professor Barbu said, it is not clear how to implement. So we're talking about the organization of the reception network. The case law mentioned CIMADA, and we also have the Hagbin case against Belgium that interprets the human dignity in a strict way, and it's still the baseline. So in my notes it was still human dignity, but very interesting to see the shift in terminology. But it is interesting to see how we will implement this, not only Belgium, but other destination states. We will need guidance from the Commission, the EUAA, and the court to know what is this human dignity, because it's not giving nothing if you are under the Dublin regulation or also a marked status, for example, because that will be a subsequent application. So you can also limit the reception. But what this baseline is, I think it leaves open to member states to be a bit more creative, to look at how can we offer assistance, but not the residential all-in guidance, more rights for a specific group of applicants, less rights for the others. Of course, if someone is under the Dublin regulation, for me, it makes sense that civic integration is maybe not the right that they should be guided to, or that's not the main issue, of course. And same for the allocation to a geographical area. It already existed in Belgian law. It exists, but it's not being used. but it will give some marge de maneuver to allocate applicants and to keep them. Well, in Belgium, it would never be in a detention kind of way. It's rather a place where they should reside, and they cannot change that place, and they should be there at specific moments in the week, so to say. So it will not resemble detention, but of course it depends on the member state what it would look like. And these new provisions, they can help to reduce secondary movements by discouraging people to travel on. If you have an all-in residential material assistance in your first member state, it will be less attractive to travel on. Of course, we know that this is not the only consideration an applicant has when traveling through Europe, but it could limit, of course, the secondary movements. But it will depend on how destination countries transpose these provisions. Another question was, will the new directive improve or
we slowly come to the end?
Okay, I'll finish this one. It's the last one. Will it make it more easy to return, for example, Dubliners to the responsible member states? Well, the guarantees stay the same. You still a forced transfer is always difficult. Voluntary transfer will maybe be easier because you know what the first member state will have to offer. Think, of course, considering that they will have the full package to offer to this person, and then the AMMR also provides some adjustments to the procedure that facilitate the transfer, but I will not go into detail. So my conclusion is that the reception directive alone will not change the current situation or will not solve the current crisis in Belgium, but the interplay of the different rules should improve the situation. And we're very hopeful it will if everyone implements and respects, of course, the different rules we have agreed upon. Thank you.
Thank you, Nina, for shedding light to the particular features of the Belgian practice, and I'm sure that there will be some discussion on that. Our next speaker is Professor Boldiger Arnaud, as we said, and he will talk about regulating qualification, the qualification regulation. Boldiger, you have the floor.
Thank you so much. Dear all, I mean, I have spoken in front of such an eminent audience 20-some years ago at one of the Odysseus conferences and in front of such an eminent panel, so I'm not less excited than I used to be that time. I try to emulate Philippe in sticking with the law and not drifting away in more abstract ideas when looking through the qualification regulation as it stands now. It is very remarkable that it was not proposed together with the pact. It was proposed back in 2016 as a consequence of the events of 2015, but it was published together with the other pieces of the pact. Now, the aim of this short contribution is not to completely overview the new regulation, that would be impossible, but to highlight the most important changes and to classify them into good, bad, and mixed impacts, which we can then discuss whether I qualify them appropriately. In reading these slides, the assumption is that you are familiar with the new regulations, so I don't recall the details and I use the technical terms. Before coming to the classifications, a few words about the roots and the purpose of the regulation. I see it as a dually rooted document. On the one hand, it was a document responding to the failures or the imperfections of the 2011 directive when it was presented in 2016. But on the other hand, over its maturing time, the drafting period, it incorporated the fears generated by the non-functioning EU asylum system in 2015-16. Others call it the refugee crisis, which is plainly wrong. In order to have a more, and that's the purpose, more harmonized set of rules, which applies common criteria for recognizing people as in need of international protection and foresees a common set of rights for them, which would lead to higher legal certainty and transparency and an equal treatment within the EU, which is hoped to reduce secondary movements. It had to be adopted in the regulation form. So it is. Now, if we look at the rules favoring the beneficiary of the person claiming to be in need of protection, there are quite a number of them. I myself was surprised when I really compared the two documents, how many of them exist. First, the concept of family member has been extended, and that's important. It now includes the adult dependent child, and it also includes the adult sibling of a minor who is the applicant. Gender and minors enjoy much more increased attention, and I'm really pleased that Catherine and Valeria will discuss that, so I feel free to jump that topic. Many in this room and elsewhere in the world would believe that the last element on the slide, that is the rule Article 10.3, which says states must not expect applicants to exercise self-denial or discretion at home in order to avoid persecution, has been now made part of the regulation. So if you are a member of the LGBTI community, you should not be expected, that's the XYZ judgment, you should not be expected to hide your preferences, but the same with religion. And that's a very important improvement. In the context of subsidiary protection, we all know the Al-Ghafaji judgment. The Al-Ghafaji judgment made a major service to the scholars and to the applicants as well, because it made clear this trade-off. Do we have a laser here? I don't believe so. Is that a laser? But it doesn't show that. Well, anyhow, the trade-off between the individualization and the level of violence. And the higher the level of violence, the lesser the individualization has to be in assessing the need for subsidiary protection. The Diakite case, again, in line with the practice of the court, fixed that the term armed conflict can be used with a different meaning than in international humanitarian law. The court gave to it a much broader meaning. Now, both of these innovations are included in recitals 50 to 52. I do see that eminent members of the audience are taking notes. These slides will be available from tomorrow on my website, so don't bother with taking notes or taking photos. You will get, and my website is my name. Presumably you don't know my name. I'm Nagy Boldizsár in Hungarian, and so it's nagyboldizsár.hu. A lot of, I do write in the blog a lot about the people, the stateless people coming from Palestine, because it's very important these days, isn't it? And the regulation incorporates the sequence of judgment, was instrumental, as a matter of fact, in providing opportunity to the court to figure out when someone coming from the UNRWA territory can claim that protection by UNRWA has ceased. And now we have a relatively positive assessment of that. So people who are really in danger, I can quote you if you want, would get automatically recognition by now. I also consider as positive the annex of the regulation, which is 1.5 pages long, and really makes clear what has to be communicated to the recognized person. And it's not only the abstract rights, but also where those rights can be validated or enforced or implemented, to which authorities to turn to exercise those rights. Residence permits also underwent a positive change because, first of all, there's a deadline until which the residence permits have to be issued, and the latest is 90 days from recognition. And the family members of the protected persons must have a residence permit with the same length as the protected person, which was not the case. The regulation now speaks about the fees, which either should be free or a maximum the maximum of the fee should be equal to that which is charged to the nationals, that is, national treatment is foreseen, and a smooth continuity of the residence permits are also expected. Contrary to the positive changes, the lengths of the residence permit are still not harmonized in the sense that beneficiaries of subsidiary protection can still be provided with a 1-year-long residence permit, unlike refugees who are supposed to get a 3-year-long one. That much about the positive side. Now let's turn to the, I did skip one. Oh, sorry, I explained that. And now we turn to the rules which limit the rights or increase the burdens of the protected persons. The regulation allows a deep interference with family life in the sense that marriages of convenience, as I call them here, it's not the regulation text, may lead to a denial of residence permit of the partner or the spouse who is supposed to have concluded that marriage or partnership just in order to acquire a right to stay. Married minors are sort of handed over to the member states under the heading of the best interest of the minor, but that entails that, for example, the spouse of a married minor may not get a residence permit, or the married minor may not be treated as a married person, but still as an unmarried person if the state so decides. Now, footnote aside to keep you awake, I mean, in almost all of the EU member states, minors are allowed to marry. In some states, from the age of 14, provided the authority or the court or the family allows that. So we do have married minors within the EU as well. All right, now, and another remark is related to the polygamous marriages. So this seems to be a protection of the ordre public and the protection of the minors. And at the same time, the regulation allows the recognition of polygamous marriages and the children from them. So we are moving in both directions. Restrictive is the fact that the family members of the recognized persons don't get refugee or subsidiary protected status. They do get a residence permit, but states no longer have the liberty, which they used to have optionally, to extend the status to the spouse. Or the family members. That's no longer the case. The withdrawal of refugee status was optional, but now is compulsory in case the person presents a danger to the security of the member states in which the person is present, or danger to the community of the member states in which the person is present. That danger must be corroborated by a final judgment meted out for a particularly serious crime. As with the Reception Conditions Directive, here we see the same idea. Social assistance may be bound, and that's new, obviously, to participating in compulsory but free integration measures. Now, in my reading, I wonder what my colleagues think of that. My reading is that that implies sticking the person to a place. Although integration measures could be available all over the country, but I assume, for example, housing subsidy, which is one of these integration measures, would be only provided at a given place. If the person is no longer there, the person would not get that integration measure. And the last group of the rights relates to mixed impact rules, that is good and bad at the same time. The first one is the surplus regulation, what again the profession calls manufactured cases. Within that circle, the manufactured cases, that is when the person himself or herself creates the necessary conditions for being recognized. Now that used to be applicable only in case of a subsequent application. Now that rule can be applied in the first instance. And that's obviously putting an additional burden on the applicant. But in exchange, there are increased guarantees. So far, the decision maker had to take into account the Geneva Convention. Now explicitly added is the Charter and the European Convention of Human Rights. And only then can the status be denied, and those minimum rights have to be guaranteed. The otherwise meager literature on the regulation deals with the internal protection, or as we used to call it, the internal protection alternative, and that's a significant change. So far, or up till 2026, states are free to decide whether they want to assess it and apply it, and therefore deny status. Now it will become, or then it will become compulsory to apply the internal protection alternative. The carrot is that not in every case. So if the persecutor is the state or a state agent, then the states need not and should not investigate if there was or if there is an internal relocation or protection alternative. But then there's an exception within the exception. I wouldn't bother you with that. We are making great progress because I still have, in my calculation, 3.5 minutes. Is that true, Achilles? That's another provision which is much discussed in the commentaries. That's the access to the long-term residence. And you have to read the regulation till the last paragraph, last article to see that, which amends the long-term residence directive. And essentially it says, if the recognized person moves in an irregular fashion to another and is found there to stay there or reside there, then the period spent from the moment of recognition until that moment is lost. So it is lost from the 5 years, which can lead to long-term residency. Now, the rules so far, the carrot, the counterbalancing element is that so far, the half of the period of the first 18 months was counted from launching the application till the recognition. Now, all of that period is counting. So people gain 9 months in getting to the 5 year. And now I'm getting to the conclusion, Chair. And conclusions are 3 slides. I think that the qualification directive has a different spirit than most of the pact, and that is because of its origin of 16 and another historic context in which it was first conceived of. The pact, in my reading, I do apologize for those who wrote it, is fear-driven, sacralizing, stretching, or breaching human rights, and many of my colleagues today pointed to that direction. The qualification regulation is a mixed bag, good and bad. We saw that with others as well, reception conditions, as we heard it this afternoon. Now, it aims at eliminating the divergences and the differences among the member states, thereby reducing the lottery element of the common European. That it should no longer be a lottery whether you are recognized in Bulgaria or Sweden. You should get the same treatment everywhere. And the same grounds should be enough for recognition for the same protected status. It's also expected to reduce the secondary movements, which would be good. Now, there is a balance between the restrictive elements and the positive elements, and we have reviewed that, so I don't have to go into detail. And the last slide of the conclusions is that if I put my rather descriptive short presentation into context, the context is that the real danger comes from other elements of the pacts. As we already saw, from the AMRRR, the screening regulation, the border return procedure, the crisis regulation, these are the ones which will really cut into the human rights and the dignity and the well-being of the applicants and the recognized persons. And then the overall conclusion, exceptionally printed in bold because I really wanted you to see it and read it, is that if asylum seekers do not reach the EU territory or do not have access to the fair procedure on the merits, then both the virtues and the shortcomings of the qualification regulation only have symbolic importance. I thank you for your attention.
Thank you, Boldizar, for this fine presentation of the topic. And I have to say that your conclusions were wonderfully framed. Even if somebody had not fully paid attention to the details, the conclusion has said everything, and this is great. Thank you for that. And now we have our next speaker is Dr. Catherine Waring on the vulnerability discussion. You have the floor.
Thank you.
Catherine.
So just waiting for the slide. Good afternoon. Yes, we have heard many calls already for vigilance and concerns over the respect or risks of lack of respect of fundamental rights in the new pact, fundamental rights or human rights. What we would like to focus on now is one element of the new pact, which, although it also has its flaws, may also be a tool for effective protection of human rights, and that is the concept of vulnerability. The tricky part, or one of the tricky parts, is that vulnerability is defined nowhere in the new pact, but it is everywhere. It is in almost every instrument of the new pact. There is at least a mention of vulnerability or very similar concepts. So let's try to make sense of these many mentions of vulnerability, and hopefully then, if we make sense of them, we can perhaps also make good use of them. So our plan is to first, I will present you, try to briefly address the main questions, what, who, why, vulnerability, to try to circumvent the concept. And then Valeria will focus specifically on one instance of vulnerability and how it is being protected in the new pact, and that is gender. So that will be our second part. Starting then with what is vulnerability? First, as I already explained or mentioned, there is no definition of vulnerability in the new pact. There is a connection with the notion of special needs or certain types of needs. So sometimes it's special needs, special reception needs, sometimes it's the needs for procedural guarantees. But this connection is not systematic either. Sometimes it seems like having special needs is a category of vulnerability. Other times it seems to be equated. So it's really not a systematic connection, but it is still relatively a constant across the different instruments of the new pact. And what we have also, so in the absence of a definition, is actually not one list, but many lists. So we have open lists, and they are not the same instruments of the new pact, which of course makes it also more difficult to make sense of. But depending on the instrument that you look at, depending also sometimes on if you are looking at the recitals in one instrument or if you are looking at the actual provisions, you will find different lists. So then you have to see exactly how to combine these, but you have, for instance, stateless persons, you have pregnant women, elderly, children are very, very often mentioned as vulnerable persons. Unaccompanied minors even more. So there are many, many categories, seemingly, of vulnerable individuals. What we also can see, so it's very difficult to have a definition or to have a full list, but what seems to emerge from the different instruments is at least a pattern that vulnerability is not only about the individual characteristics of a person, but also the specific context. So the specific situation in which that person will be, depending on where we are in the screening phase, where statelessness is mentioned as a vulnerability. So it's a kind of perhaps procedural or administrative vulnerability. In other instruments, such as the Reception Conditions Directive, statelessness is not mentioned, but pregnancy or being a child qualifies as being a person with special needs. So we always have to pay attention not only to the individual characteristics, but also to the specific context. And so vulnerability, therefore, can vary depending to where we are in a procedure or within the scope of which instrument of the new pact we are. Right. And one final point on what is vulnerability. Very often, these categories will echo some human rights instruments. They could be the Charter, they could be the European Convention on Human Rights, they could be also the Convention on the Rights of the Child. Unfortunately, these are not always explicit connections, but at least we have these echoes. We have to think of all the instruments to which these various situations of vulnerability can correspond. So that can also help to put some content into the notion. Then, how does it work to actually identify vulnerability? And when does that happen? Here, there is one relatively constant requirement. So also it's not always phrased in the same way in all of the instruments, but there is a requirement that the staff, so the staff of the authorities of the member states is qualified, is trained and qualified to identify vulnerability. So here already there is a requirement, even before the procedures actually start to be implemented, but there is a requirement of training and qualification and knowing how to detect vulnerabilities. And that, if we want to do things correctly, that will probably be a lot of work, given the very long lists and the very diverse lists of vulnerabilities that I just mentioned. And then the detection of vulnerability should happen, and at least that seems to be the idea, also in many contexts within the new pact. So it could be during the collection of data, which should be to a certain extent. So at least when it comes to collecting fingerprints, personal information, there should be attention paid to vulnerable persons and to children. And then we have a variety of other requirements which show that, in fact, you have to have a detection of vulnerability possible at every stage in a procedure or in the succession of procedures. Okay. And even in the crisis regulation, there is a tiny mention of vulnerability. We could discuss the extent of what this means, but it is really across all of the new pact, the need to detect vulnerabilities, that is also a constant. And what is the purpose? What is the point? Well, there are operational consequences to detecting vulnerability, to identifying a vulnerable person. So first, it's not only about each of the instruments, but again, as was mentioned several times today, it also matters to take into consideration the connections between the different instruments. So it's not perfectly seamless at all, but there are some connections. So for instance, in the screening regulation, we can read that what has been identified or the elements that have been collected during the vulnerability check can be reused for the purpose of applying then the other instruments, such as the Reception Conditions Directive. And then there are also specific operational consequences in the various instruments. So for instance, accommodating special reception needs, special procedural needs, and of course, perhaps not for everyone, but ultimately, also when it comes to assessing the need for international protection, it is also, after all, a question of assessing whether someone needs protection to avoid harm. So it's also, in fact, applying the Geneva Convention is also identifying a form of vulnerability. Right. So we have these different elements that hopefully help to make a little bit sense of the vulnerability in the new pact. And now Valeria is the best person to develop the gender-sensitive approach in the new pact. So I leave the floor to her.
Thank you, Catherine. I have the impression that when I introduced the speakers at the beginning, I omitted to say that the Dr. Catherine Waring is with the European Institute of Public Administration in Luxembourg, and Dr. Valeria Lareva is a lawyer with the Foundation for Access to Rights in Bulgaria. So I apologize for my initial omission. And Valeria, please take the floor.
Thank you. Thank you, Catherine, for mentioning that I'm the best person to speak about the example of gender. Actually, I should make the disclaimer that I am not an expert on gender. And the occasion on which Catherine has kindly proposed that we write a block article together on the vulnerable persons in the new pact. And why now we have this presentation together, and also thank to Philippe for proposing that, is that I have been the lawyer representing the applicant in the case of the Turkish woman that reached the Court of Justice of the European Union. It is known as the WS case, C621 from the year 2021, that was issued in January this year. And I represented the applicant before the national authorities, also before the Court of Justice of the European Union. So this is the occasion that I have been invited to speak about this concrete example. You know that in the Istanbul Convention on the elimination of all forms of discrimination, on preventing and combating violence against women and domestic violence, there is a legal definition of gender. Otherwise, in the new pact, we do not have such a legal definition. But in this regard, we have to take into account international law, as explicitly stated in Article 78 from the Treaty on the Functioning of the European Union, and also confirmed once again explicitly in the judgment of the Court of Justice of the European Union in the WS case, specifically with regard to two international treaties. The first one is the CEDAW Convention, the Convention on the Elimination of All Forms of Discrimination Against Women, that the EU is not a party to, but all member states have ratified this convention. Therefore, it is considered a relevant treaty in the terms of Article 78 of the Treaty on the Functioning of the European Union. And the other very important international treaty is the Istanbul Convention. Regardless of the fact that Bulgaria in particular, that is the country from which the preliminary ruling request came from, is not a party to the Istanbul Convention. We have an explicit judgment by the Constitutional Court of Bulgaria that it is contrary to the Bulgarian constitution. Nevertheless, as you know, the court in the WS case stated that this convention should be, the Istanbul Convention should be taken into account when interpreting EU law. And more concretely, Article 70 of it, that is focused on gender-based asylum claims, that it explicitly states that gender-based violence is a form of persecution, that there should be gender-sensitive interpretation of the Refugee Convention grounds, and that parties to the convention are obliged to develop gender-sensitive reception conditions and asylum procedures, and also qualification when examining applications for international protection. I'm going to look at the three aspects that Catherine mentioned at the beginning: the procedural one, the reception conditions one, and the qualification one. So first of all, we have the asylum procedure regulation. I have focused my attention on three main points. The first one is Article 20, that prioritizes for specific assistance the cases that involve victims of torture, rape, or another serious form of psychological, physical, sexual, or gender-based violence. So we have prioritization of these groups of asylum seekers in the referral mechanism in Article 20. The other accent is Article 21, that allows for exceptions from the accelerated and border procedures of applicants that have vulnerabilities related to their gender. So we have this gender sensitive aspect here as well. And of course, the personal interviews, besides the training of the interviewers. You know that Article 13 provides for a right that is not absolute, but still it is an explicit right for asylum seekers to be able to request an interviewer and an interpreter from the same preferred or from a preferred, it might not be the same, from preferred gender. Then the reception needs and the special needs of applicants that have gender-related vulnerabilities. As it was already mentioned, Article 24 of the new Reception Conditions Directive specifically recognizes these categories of asylum seekers as might having, of course, upon an individual examination, special reception needs. This principle of early and ongoing assessment is found both in the new Reception Conditions Directive and into the Asylum Procedure Regulation, you know, the 30 days limit, but also very importantly, as early as possible, but also very importantly, the ongoing assessment. As you know, applicants who are victims of violence that is related to gender, victims of torture, etc., they have proven by the science difficulties to disclose what has happened to them at the first encounter. And of course, Article 28 that ensures access to medical psychological treatment and rehabilitation services for these groups of asylum seekers as soon as possible. And this is my last slide on gender specifically. Here I have I have put a title of this slide that 2024, in my opinion, you might disagree, but I think that it has been a landmark year for gender equality in asylum law, because we have these three key judgments of the Court of Justice of the European Union that interpret actually asylum law. And we all know that the qualification directive, currently Directive 2011/95, also explicitly states in another recital, not 30, and not 40 as now, but recital 30, that it is equally necessary to introduce a common concept of the persecution ground membership to a particular social group. And this is reiterated also in the qualification regulation. But I think that the case law of the Court of Justice of the European Union gives us clear indications how to interpret this wording. Both in the current qualification directive and in the qualification regulation, it explicitly states that in Article 10 that depending on the circumstances in the country of origin, and that is why we speak with Catherine about the contextual dimension of in which the individual vulnerabilities might become the individual characteristics of a person might become a factor of vulnerability because of the contextual context. For me as a woman, it is not a vulnerability factor to be here now, to be in Belgium, but it definitely would be a vulnerability factor if I'm to be returned to Afghanistan. So that's why we have this contextual dimension. And what we see in the case law of the Court of Justice of the European Union is that it already marks such a recognition that women form a particular social group because of the legal and traditional perceptions in their country of origin. You see the example of a woman from Turkey, the example of girls from Iraq in the other judgment that is listed, and the latest one from this month, the women from Afghanistan in the joint cases. So to conclude, and here these conclusions are joint conclusions. Also, a co-author of them is Catherine. Once again, vulnerability is a legal and operational concept, so it's very important to have this functional utility or the practical application of the rights that we have on paper. We see in the new pact progress on several forms of vulnerability, like statelessness, that is explicitly mentioned for the first time. Children, more guarantees and more gender-sensitive approach, and the individual and contextual dimensions of vulnerability that we will see how they will be applied. So the impact depends on the implementation in practice in order for us to protect, because the title of the presentation is identification and protection. So in order for us to protect the vulnerable persons, we have to first identify them. Very often this depends, the way the law is implemented depends on political decisions, on the convictions of the implementing officers, the way of thinking of society. And I was listening to the first presentation this morning about the skepticism of the implementation of the court judgments, but I remain an optimist, and I personally continue to believe in the role of the judiciary in this process, as the courtroom is the only place where we're still equal. Thank you very much for your attention.
Thank you, Valeria, for this great judgment that you presented us and that you have helped come out, and which reminds me of the Kasinga case in the United States, 1996. So it's in the same sequence of judgments on the protection of women. Thank you for that. And now it's the turn for Professor Steve Pearce, and he will comment on the topics that we have discussed.
Thank you very much. I'll jump straight in then, and I'll comment on each of the main presentations in sort of order of some of the topics that were discussed. First of all, then, the Reception Conditions Directive, the points made by Professor Barbou-Duplass. The first point about the Reception Conditions Directive being in the shadow of the rest of the Pact. A couple of points I would add to that. One is a slightly more technical point, which is there's a couple of things that were moved from the Reception and Conditions Directive current version into the Procedures Regulation, and also a couple of things moved from the Qualification Directive to the Procedures Regulation. So if you're particularly interested in those issues, some issues to do with the process of applying and the assessment, they have been moved. They haven't been completely got rid of, if you were wondering about that. Secondly, and more broadly, I would add that another way in which the Reception Conditions Directive is in the shadow of the rest of the Pact is that although this is the one part of the Pact where you can still have higher standards, it's still required that any member state's higher standards be compatible with the directive. And arguably, I'm sure member states will argue this, well, you have to assess that compatibility alongside the Pact as a whole. So, for instance, if a member state said we want to have a higher standard and give all the benefits to someone who should be Dublined into another member state, well, the argument would be surely, I imagine, that, well, that's not compatible with the directive because you have to see it in light of the pact as a whole. That's just one example there. I'm sure there could be others that would be argued that there are some constraints implicitly upon member states by virtue of the connections with the rest of the pact. Another point worth mentioning, though, sort of goes in the opposite direction, is that, yes, although we have this new exception for cutting off benefits and access to employment, or some of them benefits, if you should be Dublined somewhere else, there is an exception to the exception, which oddly is in the Dublin AMMR, rules rather than in the reception conditions directive itself, which is that if there's a plausible ground that you're a trafficking victim, you don't have the benefits cut off. And there's a very vague human rights exception too from the benefits being cut off that you can find in the AMMR. So I encourage people not to forget about those exceptions to the exception. Secondly, on the issue of the link to the border procedure and detention, a technical point first that the case law already does make that link into the current directive between the borders procedure and that ground for detention. But a sort of more ambitious argument next, which is about the links here. The reception directive still allows, in fact, a strengthened form of judicial review of detention. So my argument would be here that allows you indirectly, if the only ground you're being detained is because of the borders procedure, it allows you indirectly to claim that you shouldn't be in the borders procedure because that's the only ground for your detention. So you must be released from detention because you shouldn't be in the borders procedure. And so it allows you to claim that you shouldn't be in whatever accelerated or inadmissibility process puts you, allocates you into the borders procedure in the first place. So it allows you to do something indirectly, which the case law says you can't do directly, which is to challenge whether you're in a type of procedure in the first place without having to until there's a final decision that you can challenge. So to my mind, that could be practically very useful. Next, on the restrictions on free movement, I would add another point about consequences there, which is there's a link between these revised grounds of limiting free movement and a new ground of detention, which is quite broadly drafted, which member states, I'm sure, are very much looking forward to using to detaining more people above and beyond those they can already detain. So I think, look quite closely at that. All right, I'll move on to the qualification directive. One point to start with, yes, technically this goes back to a political agreement in 2022, but that was really a kind of ratification of a previous political agreement on the proposal back in 2018. The council had reneged and then unreneged back in 2022. So that's why, if you were wondering and looking at it closely, while there are many references to the case law in the recitals and the main text in some cases of the Court of Justice on the qualification directive, they really only properly take account of the case law up to 2018. If you're looking for something, wondering why there are some more recent cases that aren't referenced so obviously, that's the reason why. Of course, this raises a more general question of how much account the court is going to pay to its case law on the second phase legislation when it comes to interpreting the pact. Obviously, member states may argue everything must be rethought, that every time they lost must now be rethought, even if the text is the same, because everything else has changed around it. And I'm sure asylum advocates will be arguing the opposite, or in some cases, asylum advocates will argue that something they lost in the past has to be reopened in light of, I think, an ambitious argument, but in light of something else that has changed in the pact. Next, on the point about recognition of family members and whether they can automatically be given status individually by member states, even if they don't qualify for international protection individually according to the rules. But I think it's important to emphasize here why that is something that member states can't do anymore. And that's because the minimum standards clause in the qualification directive has been dropped. Member states can no longer have higher standards. It's not just been turned into a regulation, but that minimum standards clause has been dropped as well. Of course, the same thing's happened to the procedures directive. So keep that in mind, because of course it does have other implications. It has implications, for instance, for the definition of particular social group. Member states must ensure that applicants who claim persecution on that ground meet both heads of the particular social group test. Now, luckily, the Court of Justice has interpreted both heads quite generously, as we heard about women asylum seekers in particular, but other cases too. But nevertheless, that's one example, and there are others. But another thing to keep in mind, though, for family members in particular, is that the regulation also says even if they don't have this option to have international protection in their own name, they still get most of the rights of those people who do have international protection. So that is sort of the case already, but more clearly confirmed and strengthened in the qualification regulation. Fourth point about internal protection. I would go back here and make another link with the rest of the pact, which is to the procedures regulation in this case. And one thing that the procedures regulation has done, it's already sort of foreseen a judgment of the Court of Justice and overturned it, that we've had since, which is to say that member states can have only part of a third country designated as a safe country of origin, or groups can be designated as falling within the concept of safe country of origin. And I can imagine member states trying to argue, and watch out for this, that is linked to the internal protection rules, which now become mandatory. That, well, if you're from the part of Moldova which isn't safe, why didn't you go to the part of Moldova which is safe? And that gets strengthened by the fact that both of these things become mandatory, both the internal protection alternative under the qualification rules and the safe country of origin. They both move from being optional to mandatory. So watch out for that sort of argument that member states might make. And finally, because I want to comment on all three, on the vulnerable groups point, 2 points I'd make there. First of all, yes, a lot of this definition of vulnerable groups is vague, but at least in one case, unaccompanied minors, it's more precise, and some of the rights of unaccompanied minors are fairly precise as well, as they are under the existing rules, but they get changed in some ways under the pact. And the final point, one particularly vulnerable group, and I'm meant to be writing about this at some point soon, hopefully I'll get the time, is that there's a lot of interesting revised text on child asylum seekers, what must happen particularly to children in terms of social care and various other aspects of their legal and social position. So, you can look at different things that have happened across the pact and construct a story about children's lives and in the asylum system and various phases and various things that happens. There's, I think, a real attempt both to boost those rights and to make them consistent and coherent across the pact. So that's particularly important for anyone involved with child asylum seekers. Thanks very much.
Thank you, Steve, for wrapping up our presentations with your comments on all three topics. And now it's the time for the discussion. I think we have 15 minutes. Yeah? Okay, so let us begin with those attending online. Is there anybody online who would like to put questions? Yeah, no, we don't have a question from there. Okay, let's go on here. And I have seen a hand in that direction. Yes. Elspeth.
We are part of the organizer of the Dutch Council for Refugees. I have a question for Professor. Thank you very much for your presentation. There's something about the qualification and regulation that worries me. I'm curious to know whether you're worried as well. It's Article 4 about the assessment of the facts and circumstances of the assignment. Now, the directive that we have right now, it says that it's the duty of the applicant to submit the claim. Can you hear me now? Yeah, this is better. Yeah. So in Article 4 right now in the directive, it says that it's the duty of the applicant to provide the elements of the claim, but in cooperation with the applicant, it is the duty of the member state to assess the relevant elements of the application. Now, if you take a look at the language of Article 4 right now in the regulation, it says, okay, so the applicant has to submit all elements, but for that purpose, applicants shall fully cooperate with the determining authority and with other competent authorities. And it basically says they have to cooperate with the authority. So it's switched around. It's now no longer that the member state has to cooperate with the applicant, but the applicant has to cooperate with the member state. Now, with respect to the duty of cooperation, there's a sensitive case law of the Court of Justice, which basically explains that you can't expect the applicant to provide every type of evidence that you want, and that sometimes the member state has to go and look for the evidence. That's very valuable case law. Do you think that because of the language has changed right now, that's a cause for concern and that the content of the duty of cooperation has changed? Now, I know that to a certain extent we have to wait for new case law of the Court of Justice, but I'm just curious to know if you're worried as I am. Thank you.
Anybody else?
Yes, thank you very much, Konstantin Ruschka. I have a question for Bolsha on the family asylum, because Germany has this week published the law, the proposal for the transposition, and basically said, because of Article 23 of the Qualification Directive, we cannot keep our provision on family asylum, extending the full status. And if I understand you and Steve Pearce, you see it the same way. I wouldn't see the LW judgment of November 2021, or wouldn't interpret it in the same way. I think it's not so much based on Article 3, but on the wording and not changed wording of Article 23 too. And would you think that an argument could be based on that, or are you really sure that it's not possible to have some kind of family asylum? And if I may, I also have one question for Valeria Ilyareva on a good year on for gender equality. I see one doubt in these three judgments, and that is it's a binary world of two sexes. And I'm not sure whether other groups of the LGBTIQ plus community would have been protected in the same way. How do you see that? Thank you very much.
When there was the remark about the rationale of reducing reception condition to Dublin transferees. And the idea being, well, it is normal that we should, reduce those benefits because those people are going away, in a sense. Well, first of all, let's, for the sake of the argument, assume that there is a reduction, but that the charter is still respected, so we can evaluate that part of the problem, which is probably the main issue here. But first of all, I would take issue with the fact that the benefits are suspended from the moment that the decision is served, which, if you look at the law in any other area, would be considered something a little bit barbaric, because that decision could still be annulled, quashed, whatever, and you are already taking away the benefits from somebody who might eventually not be transferred. And just what a factual element to this, last year, 1 people out of 10 that had to be transferred was transferred. It was a particularly bad year, but on a good year, it's 1 person out of 4. So I would still question the assumption that it's okay to take away those benefits because those people will be away soon. In the very vast majority of the cases, they're not going anywhere.
I have a short question regarding vulnerability assessment or identification. I was always promoting this identification of vulnerable persons. I remember quite a long time ago when the concept was developed and we had the first judgments on the special needs of certain categories of persons. Just recently, perhaps as a follow-up to the vulnerability of older person was a bit criticized, saying they are seen as a burden. I also saw it for the area of asylum applicants for international protection. Did you see any signs of saying they are a burden, or is vulnerability assessment really, I think it is, but it's more a provokant question. Is it necessary? Or did you see any criticism regarding this labeling as vulnerability or vulnerable person? Yeah.
Can you please close up with the microphone like this? The microphone is okay.
Just a little bit closer, because online. Yeah, but they didn't hurt. Sorry.
Okay, so I told my question. I really agree to vulnerability identification as necessary. Well, I thought that there was criticism of seeing vulnerable person, older persons as vulnerable, and as a burden. And just recently had to do with projects on international protection, where they also said this identification of vulnerable person is a labeling of them. It's a kind of discrimination.
Any question from the online participants? No? Okay, we continue from here.
Is it better to have such a very open list of the vulnerable persons, not have exhaustive list? Because sometimes we are not thinking about the new categories of the vulnerable persons, which may be in the future. So would it be helpful to have a list of the vulnerable persons, or is it better to have it open like this? Thank you.
So I have the impression that we are at the end of the questions. So I think now that it's time for the speakers to respond, and it's good to have a productive disorder. That is, whoever wants to respond can begin, and then we go on like that.
If I may start, then I would ask Steve to answer the second question of Tino, because you are much more qualified than I am to do that. As to the first question I received, again, I can't assess what the court will do, what the state practice will do. I do know the same change as you do, and it's significant, I agree with you. But my impression is that this kind of obligation to fully cooperate and be present, as in the present, otherwise shortened Article 4, that lays the foundation to sanctions which might be related to reception conditions or domestic law, purely national law, saying that if you are not fully cooperative, then all kinds of presumptions will be accepted concerning credibility, for example. So that's where I see the difference, the moving away. And I hope that Steve will help me out on Tino's questions about family asylum. Tino, I'm not sure I fully understood what you said, but I hope that you would, Steve.
Yes, I mean, my understanding of the case law is that the only reason that member states were able to give family members international protection status as individuals without considering their application was because of using the power to have higher standards that's set out in the current directive. So once you remove the power to have higher standards, as the regulation does, member states can no longer do that. So that's my reading of it. Member states can no longer do that. Now, having said that, you know, it's still worth trying an argument, I suppose. I might be wrong. I mean, I thought the Court of Justice would say that transit was enough to create a connection with a safe third country. Of course, the Court of Justice said it's not enough to have a connection. So, of course, why not try the argument and see if I might be wrong. Can I just say something about the question about benefits in Dublin? Yeah, I think definitely if a Dublin transfer doesn't happen, there's an argument that at some point, at the point where the member state that's trying to throw the person out becomes responsible again, at least at that point, they can no longer restrict their benefits, and access to employment starts to accrue at some point too. Another point I'd make in this context is this is another opportunity for indirect judicial review. So as people pointed out earlier today, lots of grounds of when you can challenge a Dublin transfer will be removed. But if the reason that you're being denied benefits, and there are other reasons, but if the reason that you're being denied benefits is because of a Dublin transfer being notified to you, well, you can challenge the removal of the benefit. You get judicial review of that. And in that context, you could argue that it's wrong to give you the Dublin transfer. They've misinterpreted the rules, for example. And this is also an area where you can get indirect judicial review because of detention. But the only ground you're detained is because of a Dublin detention, which is also in there, retained in the Reception Conditions Directive. Surely you can argue I shouldn't be detained because I shouldn't be transferred under Dublin, even if you couldn't challenge the transfer as such. So I'd encourage anyone who'd be out there wanting to challenge these things to think of those possibilities.
If I may follow up on this, that's a really interesting point, the last one. In Belgium, it would result in really interesting case law, because I think detention, the Dublin decision, and the withdrawal of benefits are three different courts. So it already happens sometimes that, for example, the Labour Court, which is responsible for the reception decisions, well, some tribunals are convinced that the appeal should be suspensive, so the argument against decisions that are taken by our reception agency, which is very complicated, but which is in line of what you said. And I think my reply is twofold, because actually what you are pointing at is that the appeal doesn't have a suspensive effect, and that is actually the issue you are talking about, because if it were suspensive, there wouldn't be any consequence, of course, to this notifying of the decision. And then my second point is that, of course, 1/4 has been executed of the transfers in a good year, so to say. But we also have to look at the obligation of the applicant to return himself. And whereas now the Dublin system, we all know, is not very efficient, and we look at organized transfers by the member states, and even transfers between Belgium and Germany sometimes don't happen, not because the Dublin decision was wrong, but just of logistical issues or refusal by the applicant. So I don't think we can use these numbers to say that we cannot have any effect of Dublin decisions because we only execute 1/4. Then we turn around. But I think the essence is rather the suspensive effect, rather than already having the consequence after the notification of the decision.
Okay, I will reply to the point made by Professor Hruska on the binary wording. I would like to make 2 points. One is on women, and the other one is on LGBTQ plus persons. As stated in the 1979 Convention on the Elimination of All Forms of Discrimination against Women, women have been disproportionately affected by domestic violence, by all these discriminatory measures, to say the least. In the case of the applicant, in our case, the case that was referred by Bulgaria, it is a woman who was subjected to forced marriage, then to attempts for honor killing, etc., because she is a woman. Otherwise, this wouldn't have happened to her if she was from the male sex. And that is why I think that it is reasonable to have special attention on women and to place more focus on them. At the same time, I agree that LGBTQ plus persons should also be in the wording of the judgments and the legal documents, and we see such a progress in the qualification regulation. They are explicitly mentioned. We have explicit provisions that say that they should not be obliged to hide their identity. We have explicit mention of gender expression apart from gender identity. So we have progress in the new pact in this direction. But in order for us to see case law, we should have progress in the public awareness and the public opinion. In my humble experience of 23 years of being a practicing lawyer, I see that even for us to achieve a progressive judgment, there should be some public consensus on that topic. And this judgment will mark the level of not only public awareness, media coverage, but also progress of the European civilization. And I think that we have reached that level with regard to equality between women and men in Europe. But for LGBTQ+, we still have quite a way to go. For example, I can give a very personal example to take this opportunity. In September, we had a judgment in the Changu case. The case of a very vulnerable person who has been an undocumented migrant in Bulgaria for 27 years. Again, I have been his lawyer before the national authorities since my legal clinic students. As a legal clinic student, I took his case. So for nearly 20 years, I have been his lawyer, imagine. And there is no regularization pathway for him in Bulgaria, but in the eyes of the law, he's an undocumented illegal migrant, so very vulnerable person, but we didn't achieve the same success. Although it was so close to my heart, I wanted it to have bigger progress in the judgment that was issued by the Court of Justice of the European Union on the 12th of September this year. But just the public awareness, the understanding of the public doesn't match that level, and that insight that I have as a person who knows him. He's very vulnerable, in very fragile health condition, undocumented, but still we do not have such huge progress with that judgment. And the non-exhaustive list, I really insist on that non-exhaustive list as a practitioner, because in practice we have cases that are not included in the law. The Bulgarian law currently contradicts the directive, because the directive gives a possibility to add other categories of vulnerability, and the Bulgarian law closes it. It finishes and this full stop. And we consider this a violation of the EU law. And we don't like that in practice, because the life is richer than the law. Law follows life, not vice versa.
Yes, so to follow up on this, so I completely agree. And I think also, especially from a human rights perspective, because the vulnerability concept is also there to address difficulties in exercising one's human rights, right? So it's addressing vulnerability should allow for the effectiveness of human rights. And so as we have already discussed, it is also, it has to do with individual characteristics, so inherent to the person, and then also to a changing environment. And the new pact has created also something like this. It's a new framework with so many unanswered questions, as we have seen today already. So in this context in particular, it's very important. It's great that we have some categories where we know that there is vulnerability, but it's very important for the effectiveness of human rights that these lists are open lists. So, and there was so Ulrike's question on I think what you were referring to was a risk of victimization of, so, you know, putting a label on someone and leading to victimization, or perhaps even a form of re-traumatization for persons who have already been through horrendous suffering. I think that's, I mean, the point of having detection of vulnerability and then concrete operational consequences is precisely to avoid this. But it requires a very a subtle approach. This is why there needs to be, as I was saying before, but genuine training. And I think it is there, the requirement is there in the pact, because the authorities or the persons who will deal with vulnerable persons, who will identify them and decide what consequences to give, they need to have the sensitivity. It means not, for instance, not putting a person who has been a victim of domestic violence in the position of having to tell their story in front of their partner, for instance. So vulnerability if we really comply also with the operational requirements, I think we can avoid the consequences that you are mentioning, although I agree that the risk is there. So there is a challenge there, of course.
Any other comment? No? So we have reached the end of our day. I would like to thank the members of the panel for their patience, creativity, and scholarship. I would like to thank the participants online and in presence for remaining here until the end. And I would like to thank Philippe, who has been here since the morning. He has not moved from his chair and being ready to streamline things that might go wrong. So let's give our next meeting for tomorrow morning, 9 o'clock we begin. Thank you.